Now, you've gotten out of jail, or your family member's out of jail, or maybe they didn't get out of jail. What happens next? Well, if your family member or you did not get out of jail, then we need to consider a motion to set if it is a violation of probation or community control, or reduce bond if it's a new case. So we want a motion to set or reduce bond. What's the importance of this? Well, often that will happen before the first court date on your paperwork, because your next court date after first appearance, as we move down that upside down letter Y, is a legal proceeding known as arraignment. Now, Rule 3 is the Florida Rule of Criminal Procedure that governs criminal law. And rules of procedure are basically how you do things. If you look in Rule 3, you will not find terms like plea day in the rules of criminal procedure, yet there are counties like Okaloosa and many others across the state that do not call arraignment court arraignment. They call it something like plea day. It's important to know these things, and as a consumer of legal services, you can't possibly learn all of this information on the fly. This is why you want a team led by an expert to handle it, because if your family member or you did not get a bond, or you have a bond that's not makeable and deserve a lower one, then a judgment call needs to be made about a motion to set or reduce bond, and it needs to have a notice of hearing and be put on the court's calendar so that it can be heard before your next court date, which is arraignment. At arraignment, judges don't want to hear bond motions, and in the next video, I'm going to tell you what they do want to hear and what you should do and what you absolutely should not do at arraignment court.